Now, for this morning's session on employing foreign nationals now and post-lockdown, I'm very pleased to be joined by my partner, Adam Williams, who I'm sure many of you will know is something of an expert in this area. So it's great that he's going to do most of the talking this morning. This session today will probably run for about 50 minutes to an hour. What we'll do first of all is Adam will run us through the sort of situation in terms of the current position, bearing in mind some of the changes, some of the relaxations that government has made to the current situation in view of our current lockdown state. We'll take some questions then, and after that then Adam will look forward. Of course, we've got Brexit effectively as at the end of this year, and Adam will outline the direction of travel. Many of you again will know that a bill was reviewed by the House of Commons, in fact, only on Monday of this week, as regards the new immigration scheme that's proposed to be brought into effect. After that, we'll have hopefully time for a few more questions as well. Please, if you would like to submit some questions, very much welcome to do so. Please can I ask you to use the Q&A facility on the bottom bar there of your screen, rather than the chat one. The chat one tends to become a bit difficult to work out which are questions and which is just chat as between delegates. So if you've got a question, please do ask them and pop them in that Q&A bar. As with previous sessions, if for whatever reason we don't manage to get to answer your question, we will circulate a sort of a roundup of the Q&A at the end to all of those who have joined today. So really, I think without further ado, it comes to me to ask Adam, please, if Adam, you can take us through the first part of your presentation.
Thank you, Rustam. Yeah, good morning, everybody. Rustam's very helpfully set the scene there for what we're going to be looking at today. So first off, I'm just going to give you just to cover a couple of those points again and set the scene a bit further. An overview of the two areas that we're looking at today. If we can just move forward onto the next slide. We've got two broad issues, as Rustam said, arising from the pandemic. So starting by looking at the now situation that we're in as employers and foreign nationals when it comes to work visas. The first is the impact of the pandemic on those who are already here with leave and those who are due to be coming. And also that will include people who were here but had been outside of the UK when all this happened and lockdown began and haven't been able to return. A number of you may be experiencing or seeing issues with that, which is obviously primarily an issue for the individual, but has a direct and immediate impact on the UK employer as well. And also an issue for now is planning for when free movement ends, which is due to be at 11 PM on New Year's Eve, and how you're going to deal with employing should you need to, foreign nationals under the new system post 2020. And of course, there may be an overlap between the current situation and that future planning exercise. And so we'll go into that and what 2021 onwards is looking like in more detail in the second broad half of the session. So if we just start by looking at some of the issues, potential issues that you might see at the moment. Obviously, this is driven by the impact that the pandemic has had on individuals' ability to travel in and out of the UK. It's not impossible to come in and out of the UK, but in most instances, there will have been some impact on an individual's ability to leave the UK. For example, where their leave expires or they need to leave to make a new application for a visa because it can't be done in country. And also to enter the UK. So visa application is granted for leave to enter, but the individual is not able to travel within a period that's necessary for the visa purposes. And so those two issues arise. It can also have an impact on your ability as employers to carry out your right to work checks, which of course are applicable not just to foreign nationals. Under the Home Office guidance, right to work checks should be conducted with all employees. And the impact can be on the individual in terms of their ability to provide you with original documents, but also on the employer in the terms of their ability to have sight of those documents in the presence of the holder to confirm it's satisfactory. And of course, this is all relevant to establishing the statutory excuse from civil penalty should that person subsequently turn out to not have the right, or if you're a registered or licensed, I should say, sponsor of visa holders, to comply with your duties to conduct all those checks in accordance with the guidance. Another issue is, as some of you unfortunately may have been dealing with in the last couple of months, there may be a need to reduce salaries or to furlough staff or both. And that raises questions in this context of changes to sponsored workers' circumstances. So if you're sponsoring a tier 2 work visa holder, are they permitted changes, or do they trigger a need for a fresh, what we call change of employment visa application? And we'll come on to some of the knock-on effects of that. Reductions in salaries, possibly to below the amount the employer is obliged to pay if you're the sponsor throughout the term of the visa, that can have an impact. Can you reduce the salary without breaching the visa conditions or your sponsor license? So just before we look at some of those issues in more detail and what we do know from the Home Office about its position on them and any concessions, I thought we'd take a quick poll. That we might be having some issues with the poll at the moment. So if we just move on from that, and we can always come back to it. I suspect that we would find that there'll be a mixed bag, and I'd be very surprised if the vast majority of you don't have at least a handful of foreign nationals, or indeed you might still be working through identifying the exact number that you employ. And obviously what will be equally important is working out as best you can, it's very difficult, how many you anticipate you will employ or need to recruit in the medium to long term going into 2021. But skipping past that, let's look at the in-country, what I've classified as the in-country issues, and what Home Office guidance or support we have, if any. So if you're unable to leave or apply for an extension before your current leave expires, looking at that issue. So you're here with valid leave, but your leave's going to expire and you're not able to get an extension because, for example, visa application centres are currently closed, and you can't leave. What the Home Office have said is if your leave expires between 24th January and 31st of May, so we're coming right up to the back end of that period, then as an individual visa holder, you can request, and you must request if you want it, an extension up to the 31st of May. So anybody benefiting from this will benefit most if they've had a visa expiry date already. That's the present concession, and it's an online form on the Coronavirus Immigration Help Desk. Google search gets you there very quickly. It remains uncertain whether people will be able to regularise their leave by then. At the moment, it looks like they won't be able to, because we're coming up to 31st of May and people won't have been able to make applications for visas if you look at the latter category. So we're lobbying, my team along with others in the Immigration Law Practitioners Association, for an extension to at least September, but it's a case of keeping an eye on their web pages, which we've got links for later in the presentation, to see if and when that comes through, as they're certainly leaving it late, to give people some comfort on that. The next point is those who are in country who need to apply for a new visa type, requiring them to leave and return. Well, again, if and only if you're in a category where the leave expires between 24th of Jan and 31st of May, the Home Office have granted a concession to say, that you can apply from within the UK where you'd normally have to leave. And there's that concession would apply to things like somebody with a Tier 5 Youth Mobility Scheme visa, where you won't be the sponsor of that visa holder, but they will be employed by you, and they normally have to leave the UK if they want to switch into a Tier 2 worker visa to stay much longer term. If their expiry date's falling in that window at the top of this slide, they may benefit from that concession to be able to apply from within the UK. Just moving on to the next slide. What about out of country then? Well, again, some Home Office guidance and support, not in all areas. It's a mixed bag. Applicants who are abroad and unable to apply from the country of residence. This is a difficult one, and there's no loosening of the rules as yet being confirmed. And it relates to the fact that somebody might have been travelling to a country or was in a country which isn't the place where they live and is outside the UK, and got stuck there due to the pandemic, they would ideally want to apply, if they had always due to be in the UK by now, from that country and come straight here possibly. But if they did at the moment, it wouldn't be valid, and they wouldn't be able to make the application, or may have it refused on the basis of applying from outside of country residence. So there's no loosening of the rules as yet. Obviously that becomes more and more important as lockdown eases and people can travel and start making applications at the visa application centres. Criminal records, documents and English languages certificates, which are often required for applications for leave to enter. The indication from the Home Office is that, and it is just an indication, I really need to stress that applications can be made without those documents, which are normally required to be submitted when you put your online form in and then go to the application centre, and the requirement for them will be put on hold by the Home Office. Problem with that is it isn't written into formal rules or guidance yet, and an individual or the employer on their behalf may commit thousands of pounds, low thousands, but significant sums of money in making the application, and will have to hope and expect that that issue will all resolve itself. Either they will have the documents when required, when that's taken off hold, and or that the Home Office will accept the form of documents they have. So it's an unfortunate situation for individuals to be required to take that risk if they want to move forward at present. Last point on this slide is the 30-day vignette period. So classically, applying for a visa to come to the UK from outside, you would receive what we call a vignette, so a stamp, passport stamp, entitling you to travel, to gain entry to the UK, and then obtain within a short further period your actual credit card style or driving license style proper biometric visa. There's a 30-day period on that, so you can see how somebody who's been granted a visa may find that they run out of time to travel due to travel restrictions. There is a concession for that. The Coronavirus Immigration Help Desk service online is now available, and individuals can request an extension, no charge for that, to a later validity date, which will be very useful, I'm sure. What about if you're unable to collect? So you've managed to make it into the UK, which will be something of a success in the current difficulties, but you're not able to collect your BRP, your biometric residence permit, the actual driving license style visa, within the usual 10 days. Well, unfortunately, we've got no actual guidance issued on this from the Home Office yet, but it does say that applicants won't be penalised for inability to collect while the coronavirus measures are in place. Of course, there's not enough detail there to know exactly how severe the measures might need to be to benefit from that rule, which can be difficult in terms of individuals maybe having their own view as to whether it's safe to go and collect their residence permit, as against the loosening of restrictions by the government. They may not actually be entirely aligned, and the Home Office currently just says if you're unable to collect while measures are in place, and of course the inference there being because measures are in place. A visa expiry whilst the individual is overseas. No guidance issued yet on any support for that, and that's probably not going to be that uncommon. People travelling on business when this all happened, still stuck out in that country, and their visa's about to expire. Will they be able to get back into the UK, or will they be effectively treated as someone who, as if they'd never been here, have to apply for a new visa before they can re-enter? Our hope, when I say that's our team within my firm and the ILPA immigration practitioners group that we're a member of, is that the Home Office will allow people to return on expired visas, hopefully with none or with very little need to produce evidence as to why you couldn't travel. In the vast majority of cases, that's probably going to be obvious. And it's our belief that's what the Home Office did around the volcanic ash cloud situation a few years back, although there was never any sort of formal statement that that was a policy. But you'd expect, unless something's changed that we're not aware of, that they will take a similar approach. So that's the hope. What about the sponsor, points-based system sponsor license compliance? There are some issues around this. If you're unable to assign a certificate, so the COS, for anybody who's not a sponsor yet, the certificate of sponsorship, a unique reference number to enable an applicant to make their visa application to work under your sponsorship, you might be unable to assign that, or feel you maybe can't because it might expire before the person's able to actually make their application. there are some timeline issues here, depending on how long we remain in lockdown. So one key period is there's a 6-month lifespan for what's called the RLMT, which is the advertising process that may be mandatory to pave the way for someone to come to the UK on their visa, tier 2 visa. Certificates of application are only able to be assigned in reliance on one of those advertising processes, and therefore to enable the visa application for 6 months from the start of that 28-day advertising process. So there's the first date of that 28 days. There's no concession yet for that 6 months lifespan. And I'm afraid until there is, it may be that the advertising process has to be run again if it's not looking like it's possible or appropriate to assign a certificate within the 6 months of that start date, i.e. because the individual is never going to be able to apply validly within 3 months of it being assigned. There is a concession for delayed applications in a general sense, in that the Home Office says applicants will still be able to apply. And so there's difficult judgment there about to what extent you issue the certificate in the hope that the Home Office will allow a late application if it goes beyond the 3 months. What the Home Office says is it may accept out-of-date certificates of sponsorship reference numbers if the applicant was unable to travel due to COVID. And that's a similar issue to the one we touched on earlier. What do we mean by unable? Where's the line going to be drawn on that? So things to work through quite carefully. Just moving forward. Tier 2 change of circumstances. We touched on the issues at the outset around change of circumstances to pay, hours, leaves of absence due to coronavirus, and the furlough scheme. How does that interrelate? And it is an issue if you sponsor work visas under Tier 2, because at the moment the standard rule is Tier 2 visa holders only can have up to 4 weeks unpaid leave per year. So if you change a role type, salary, or working hours, each or any of those might trigger a need to sponsor a fresh change of employment application, which could be dependent on a new RLMT, a new advertising process first, which would push the timescale out by at least a month. And of course, at the moment, those applications won't actually be validly finalised because individuals can't go to visa application centres. You'd have to start the process, but wouldn't be able to complete it. There is a concession in terms of reductions in pay in line with the limits under the Coronavirus Job Retention Scheme. So as long as it's temporary, it's part of a firm-wide approach, and we'll just come back to that in a second, and the pay will return to previous levels as soon as that approach ends. It won't be a breach, either a breach of the visa conditions or a change triggering a need for a change of employment application if you reduce pay in line with those limits. And in fact, the general position of the Home Office is that other changes won't breach the conditions or be triggering a change of employment application either. For example, reducing to part-time working hours won't trigger that unless there's a corresponding reduction in pay that doesn't satisfy this third bubble on the slide we're looking at here. Now, the policy of the Home Office is to say that your approach to avoiding redundancies must be one in which all workers are treated the same. You'll immediately see difficulties there and question marks around, does that mean as regards the entire population of your employment? Does it mean group by group? I think it's probably more worrying than it's intended to look from the Home Office, in that clearly they want equality of treatment. They don't want people taking advantage of this concession to reduce the pay of foreign labour and undercut the resident labour market. But there is that statement there, and there isn't yet any additional guidance around it to give us a tighter sense of it. Currently, there's no suspension of curtailment of leave, so the bringing to an end of leave within a short period of workers unexpectedly having their employment terminated to allow them more time to find a new sponsor. That won't be an issue for you as employers per se, in that you will have terminated the employment rather than have an issue with someone being able to continue being employed by you. But it will be an issue if you're looking for workers and someone comes to you on a Tier 2 visa and wants you to become their new sponsor, because they at the moment will still have a very short timeline, usually too short, of a few weeks, to try to regularise that. Supporting documents. So this is in the context of not right to work checks, but your sponsor license application. So either becoming a sponsor license holder or renewing, if you need to submit new documents for renewal, changes of your tiers of sponsorship, for example, that require additional documents. Do you need to submit originals? Well, it's unclear, unfortunately, and we've seen mixed messages. Some advisors in the group of which we're a member have been told electronic versions will be accepted. Others, and we've seen conflicting information from the Coronavirus Immigration Helpline. I think there's a approach to be taken on risk there as to whether you can and should still try to get the originals, or hope that you are correct in that there will be allowance for electronic versions and go ahead anyway with your application for renewal or a new license. And right to work check. So there's quite a big concession here from the 30th of March. You can use video link now to satisfy a right to work check as being in the presence of the holder. And the applicant can send you scanned documents or a photo using, and this is specifically in the guidance, an email or mobile application instead of sending originals. We don't know quite how important that reference to email or mobile app is going to be in terms of the method of transmission, but clearly it'd be sensible to use one of those to avoid any wrinkles. And employers must still use the employer checking service where applicable. So where you've got a reference number for someone who's applied for a variation or extension of leave, you put that in online and you seek a positive verification, giving you 6 months period where you still have your protection from civil penalty on right to work issues. Problem areas remain though, principally in that the list of valid documents that might give you a valid right to work check don't include some of the new examples that have arisen from this situation. So for example, the document verifying that someone has had their visa extended to 31st of May under the coronavirus concession, that isn't actually on the list. So it's not perfect, but some quite big concessions in terms of the practical steps for doing right to work checks, which should enable in the vast majority of cases for you to still validly find your way through that if you are hiring anybody at the moment. Okay, so just to recap before we move to some questions, important to understand the impact of the situation now on non-settled workers, how it might influence the timing and outcome. Do you know where they are, their travel plans? Are there any difficulties associated with that? If they're stuck abroad, for how long can they work from there if that's what you're doing, etc. You probably need on the right-hand side there, as you look at the screen, to adapt your right to work check procedures to the extent that you're recruiting, as we've just discussed. Ensure you have all relevant changes identified. Make sure when you've got groupings who've been furloughed or are going to be furloughed or have pay reductions proposed, any changes really to their hours of work or role, check whether there's anybody there with limited leave to remain. Make sure they don't require a resident labour market test and new application for a visa, and report the changes on the SMS where necessary. Most changes shouldn't be necessary if it's prompted by the coronavirus scheme, but you need to check that. And if you're applying to become a sponsor, which in our second session, you'll see the reasons why that might be the case going forward, even if you're not already one needing to renew, start thinking about your original documents for that. We've got an appendix to the immigration rules that sets out, appendix to the sponsor guidance, I should say, appendix A, which sets out the sorts of combination of documents you'll need. And therefore, if you're looking at it, it's a good idea to start looking at that now. Some useful links here that we've got, and we will follow up with those as well after the session, I'm sure. It's important to look at those links because they do change over time, and that's why we've included links rather than snapshots of the guidance. As any of you who've been dealing with employment issues around the CJRS scheme will know, there's scope for the government to change and update its position very quickly, and perhaps sometimes unexpectedly. So very important to keep an eye on those resources should you need them. So I think we're just going to move to questions now. Rustum.
Thank you very much, Adam. Well done. Apologies to everyone that we've got the gremlins with the polls this morning. I think we're probably going to have to just pass over those. So apologies for that. And yeah, we've got a few questions there. There we are. And Adam, I think one question that somebody submitted before the session this morning was really just saying, well, how long in reality does it take to obtain a sponsor license at the moment?
Yes. Well, at the moment, that last point, it's quite difficult to predict that we may see some delays to the standard sort of processing times as a result of the pandemic. As with a lot of things, obviously resources will be slightly lower, at least slightly lower in the Home Office to manage applications. But if you are looking to become a sponsor license holder, the Home Office still is saying it will work to an 8-week turnaround from the submission of your application. We tend to see from experience it being more like 15 weeks or so, somewhere between probably 12 to 18 or 20 as a broader brush in total from a standing start, not least because of this issue of having to gather original documents from all sorts of places, including insurance certificates, tax records that nobody's looked at for a long time, and getting those together can take a few weeks to organise, quite apart from doing the application form online. So, and of course, the problem is we don't know how delayed those steps will be due to the inability to get original documents. And as we've seen, and as I mentioned there, there's still quite a bit of uncertainty about whether electronic documents will suffice.
Okay. And another question, can we appoint a foreign national as one of our key personnel in managing a license?
Yes, the answer is yes. There's no prohibition on nationality around being a license holder, although any of the important functions of level 1 user or the authorizing officer at the top, there's a very important requirement that the person is permanently based in the UK. Obviously, that has to be lawful as well. They have to have the right to be. And so we do see problems sometimes, if you're unlucky, where the organization is growing but small in the UK, and the person with the appropriate responsibilities, authority and knowledge to hold that role isn't actually based here. That's the issue that tends to pop up if there is one.
Thank you. And one question just come in, Adam, from someone who I think was a little late in joining. Just clarifying what you've said so far this morning. Obviously, we still have, I suppose, 2 sets of rules. Is this right for those that are EU nationals and those outside of the EU? So the question, for instance, somebody coming from Australia, current position and where we are. Obviously, things like the right to work check, that isn't going to apply in the same way, I think I'm right, to EU nationals as it will to others. Just clarify in terms of what are the different, to what extent are we still running that kind of 2-tier approach?
Yeah, well, we are running a 2-tier approach until New Year's Eve, and this session is relevant to anyone outside of the UK who doesn't have settled status. I think that's the way to think of it. So if you're a non-UK, non-British national, unless you've already got settled status, you probably don't have any of the concerns about visa changes, is your employer needing to report something to the SMS, etc. But in any event, you've probably still got the travel issues. So things like returning to the UK is going to be problematic at the moment, whether or not you've still got a valid, for example, indefinite leave to remain visa if you're a non-EEA or EU national, or a settled status if you're an EEA or EU national. You're still going to have those issues at the border. So it's relevant for both. I don't want to rehearse too much the second half of the session, but going into 2021, the big premise of the proposed new system is that it shouldn't make much material difference whether you're European or non-European. It's about if you're not from the UK, non-British, everybody will be in broadly the same boat in terms of accessing and right to work and accessing the UK labour market.
Okay. Thanks, Adam. And I've just had a message saying that maybe the polls are going to work in the second half, so we might give it half a go. But
so we live dangerously.
Let's see what it really is doing it live, isn't it?
We're going to go for it. Well, okay.
Excellent. So back to you for the second part, Adam. Thank you.
Thank you. Okay, everybody. So we're just going to move forward now to the second part of the session, where we're looking at the future. And of course, this was hard enough for employers and including employers and HR teams who deal with global mobility to predict and plan for when we were just dealing with Brexit, which I touch on here because of its specific importance to free movement, but it's now made harder perhaps by the global and broader issue of the pandemic, where there's even more uncertainty as to recruitment activity and how we plan around and what we're actually going to need. So there's a lot of difficulty there. we'll try and work through some of the issues to assist with that. But I suspect a lot of businesses are going to have to make some pretty broad brush assumptions for now, that they regularly update about what their position is going to be in the future and what they're going to need. But let's just look at the background and the scene setting to looking ahead. Brexit, then obviously end to free movement at 11 p.m. That's due to the time zone differences between here and the continent on the 31st December. And there's been no indication that that's being pushed back, notwithstanding any difficulties that have arisen from the pandemic around negotiating a deal. As it stands, we can only assume that that's still the cut-off point. We've got the EU settlement scheme. In the last week or so, we've had a statement from the Home Office that 3.5 million people have applied for that already. Does re-emphasise the point that there was an estimated 3 million European nationals living and or working in the UK when we went to a Brexit vote. People thought that might be quite significantly an underestimate, and the fact that 3.5 million people have already applied suggests maybe it is. That's happening, seems to be working very well, to the extent that people seem to be able to make application with very little support or need for support and online process via phones. The iPhone issue has now been resolved. And that will give people who've arrived in the UK on or before that 11 p.m. time the ability to get pre-settled status, which will give them a 5-year run at becoming settled if they're from the EU. So a sort of long tail for the free movement coming to an end for those who get into the UK and are resident here by that 11 p.m. time. We've got, looking ahead, the new skills-based, as the government describes it, immigration system for both EU or EEA and non-European migrant workers going forward. The reliance on EU labour is obviously a big question mark. It's being debated politically. It'll be a debate or issue for you as employers. And that's a big question we'll look at in the context of this new skills-based immigration system and the removal of this frictionless ability to just hire talent from Paris, Brussels, wherever, without really any need to plan in timelines other than for things like the actual travel. We're going to have quite a shift in approach we're going to need to get used to, along with all the other changes that we're currently experiencing. And labour shortages, whether that's at a certain skill level or even at a low skilled level, and how are employers going to manage that, where they simply can't find domestically the workers that they need. So we just move forward. So we'll give this a go now. Do you currently have a sponsor license for Tier 2, which is the main worker category of the existing points-based system? So far, so good. The poll is up. It's a straight yes, no, this one. Looks like we're just waiting for the answers to come through. Okay, that's looking like that's set now at a pretty much 50-50, 49 to 51% split. Well, the good news is that whether you have one already or you haven't, I think the next session will hopefully be helpful in just either recapping on what the changes are going to be if you've got one, but in addition, if you haven't got one yet, looking at what the process might entail in terms of should you get one, how and when. So thanks everybody. I'm glad to see that's working. Let's move forward to pick a bit further into, oh, sorry, we've got another poll first, of course. How many foreign nationals, this is a almost impossible question for some of you, I'm sure. It'll be a sense, if nothing else, from you. How many foreign nationals do you envisage employing in the UK by the end of 2021? We didn't have the poll earlier, so this was intended to be a compare and contrast, but we can still use it now as an indicator of to what extent you think foreign labour is going to be relevant within your organisation. You've got three options there. Of course, some of this may be informed by the size of your organisation. There's only a very broad indicator. Yeah, so an overwhelming majority in the 0 to 50 category, which could be obviously anything from 1 to 50. And so, but that's indicative of being a relevant issue for almost all of you. a small group of you there is thinking that you may not need to, and you'll be in the Home Office's good books in that they're saying their new system is to wean employers off reliance on foreign labour. That's the way it was put before the new scheme was announced. So let's just now we can move forward, I think, to yes, some of the plans. From the 1st of January 2021, we've got the new, I've put that in inverted commas, points-based immigration system. Of course, we already have what is called in the UK points-based immigration system. Many commentators would say it's points-based in name only, but we do already have one. We've got a bill debated in Parliament this week. It's a political hot topic, so I won't get drawn into that, but there's positive and negative things to be said about the bill. The big important part of the plan, I suspect at this stage of just outlining it, is that you need approved sponsor status if you're an employer and want to employ someone to come to the UK and work for you from outside of the UK. The sponsor license regime, as it's currently described, which is now seemingly morphing into terminology of approved sponsor rather than license holder. That's in the vast majority of cases. There'll be a tiny minority of globally talented visa holders, people who happen to have the right to work through a very discreet ancestry route or spousal relationship, whatever. The vast majority, certainly where you're pulling the resource rather than just finding someone's applying for your role when they are already here or can be, is going to involve that approved status. Visa applications will therefore be required frequently, unless there's a trip to the UK by somebody you want to work with for business visits within Appendix V, the business visit rules. Appendix V is quite broad and generous by comparison to other European countries, certainly, which is the sort of opposite of our general restrict and what's called hostile approach to visas and immigration. So there may be some opportunities there, but it's always short term, and you can't take up employment. That's a strict prohibited activity. So limited visit rules for up to 6 months might just work, but in the vast majority of cases, approved sponsor status will be needed. So just moving forward. What's really new then? It's called a new system. Not a lot. In headline terms, there's going to be lots of detail, which is still actually yet to come through in some instances around the margins of the rules and the minutiae. But the big change is how many employers are going to need to use it for the reasons I've just described. EU and EEA nationals will now fall within the system unless they've can prove that they've come and been living here before New Year's Eve. Changes to the point scoring mechanism a little bit, but it's still, for the most part, points based in name only. Very limited actual proper trading of skills or qualifying criteria to get to the points that you need. There's been a reduction in skill level requirement, and this is about the role, not the person, from RQF6, which is broadly graduate, to 3, which is broadly A level, and that will open up the system to some, but the pay thresholds remain. So it may have limited benefit if you've got an A level type of role in terms of skill, but the minimum pay requirements are too high to justify employing a foreign national for it. And we'll come on to that in a minute on the points page. There's been a slight reduction in that pay threshold and some scope for reducing it further by trading points, but it's going to, I suspect, have limited use and benefit for most employers and scenarios. There'll be no resident labour market test. Any of you, the roughly 50% of you are already a sponsor, maybe on mute and clapping your hands and cheering now if you hadn't seen that already. It's a very prescriptive 28-day advertising process, record keeping requirements, and there'll be no cap on the number of visas required. The MAC, the Immigration Advisory Committee, said that they didn't think advertising or the cap was the best way to protect the labour market. They thought the immigration skills charge, which is like a tax on employers when they sponsor a visa applicant, is a better way to manage that and all the salary thresholds. So some changes, and they're the high level ones, but the framework itself is remaining largely unchanged. So if we move forward. EU settlement scheme, as I touched on earlier, we've got 3.5 million applications now. Got to be living here by 11 p.m. on New Year's Eve to benefit from the scheme, and that will give you pre-settled status, which after 5 years of qualifying residence, you as an EU national who'd arrived in time can convert to settled status like an indefinite leave, with very generous provisions for losing that entitlement if you leave the UK. You could be out for more than 2 years at a time. Government intends, in terms of right to work checks, you probably have seen this or been looking at this as employers, the question of, well, what do we do for right to work checks for those who are EU nationals who say they've arrived by 11 p.m. on the 31st of December and are living here, but aren't yet able to prove to us that they've got pre-settled status? Well, the government says that employers should be able to use EU passports and identity cards as evidence of right to work to cover that gap until the end of June 2021. So allow for that runoff of applications. Living and working then from 1st of January. So either you weren't able to, if you're an EU national or anybody from outside the UK for that matter, but if you're an EU national who might have had free movement rules, not been able to get in and reside by the 31st December, how is that going to work going forwards for you? Well, unless you're endorsed by a recognised body as globally talented, so a global leader in your field, which for obvious reasons will be a minority, you're going to need a job offer from the Home Office, what's now being called approved sponsor or licensed sponsor under the current terminology. You'll need to be been offered a role that's skilled to that A-level skill level or above. You'll need to be paid at or above the applicable salary threshold, and that's a visa minimum threshold, and if it's higher, also at least the amount that's set out in the standard occupational codes as the minimum for that particular role. So you have to classify and work out what your statistical classification of your role is. You get a 4-digit code, and there may be a higher minimum salary for that role as well. And you'll need to speak English to the required standard. All things that are totally alien to anyone who's benefited from the free movement rules. You'll need entry clearance, typically granting 3 years leave. It's possible to sometimes apply for more, like 5 years up front. Most employers and employees don't want the additional cost that goes with that when they know that it's extendable anyway. And after 3 years, you could apply to extend most leave periods to 5. And then that opens the door potentially to show that the Home Office, you've had 5 years qualifying residence. So you've been here lawfully doing what you should be doing and not anything you shouldn't. You haven't been out of the UK for too long, typically 180 days a year for each year would discount you from eligibility. But subject to those things, you may be able to get indefinite leave to remain, which is the existing framework for what's you might call settlement under the old free movement rules for EU nationals. EU nationals won't get automatic settlement as they do presently. After 5 years, they will have to apply for indefinite leave to remain. So how will the points-based system work? Well, you've got to attain a sponsor license, or I suspect the Home Office will start saying online, you've got to become an approved sponsor employer. That involves you gathering those documents, supporting documents, demonstrating through an online application and supporting documents you're a genuine UK employer who's suitable for sponsorship. They look at things like your structure and organisation, your HR systems, etc. Number 2 is probably linked or may even come at the same time or in advance of 1. You've got to identify a suitable applicant and assess their eligibility in terms of the role and pay under this new framework that just didn't apply at all for EU or EEA nationals under free movement rules. Once you've got your licence, you'll have to use a certificate of sponsorship. The terminology may change, but it'll be the same principle, I think, which is a unique reference number. You'll submit that or assign it online to the applicant so they can use that unique number to as a sort of key to get through the gateway to their visa application online. And then they'll apply for their visa. When all these travel restrictions end, they'll be able to come to the UK, demonstrate their right to work to you and that they got their sponsored visa, general tier 2 visa. And then you'll have to comply with all your sponsor license duties for the life of your sponsorship, including right to work checks, which are optional if employers like to take risks on these things. If you're not a sponsor, it's up to you whether you want to try to have a protection from civil penalty or not, but they're not optional once you become an approved employer. You have to be best practice on that. Record keeping, strict record keeping rules around the records of individuals that you sponsor, and you should have all your normal HR records as well. Being an employer of choice is the way the Home Office would expect to see it when they possibly come and visit you. And monitoring as well. You need to have a system to identify the activities of your sponsored employees and any changes so that you can report these. Sometimes it's within a short time, like 10 working days. You don't want to be in a position where you've lost 6 or 7 of those because the actual change or event hasn't got to you within that time, or indeed it's more than 10 working days since, and you're therefore reporting something late. What we currently have is something called an annual allocation of certificates of sponsorship. So for the following the tax year, so April to April, many employers who are currently sponsors will be given or have a renewed allocation of, say, 6, 7 or much more allocations of COS. So ones that they can pick off the shelf, so to speak, online, generate a unique reference number from and enable someone to apply for their visa to work for them. It's not entirely clear yet how that's going to work going forward. Lots of new applicants are allocated 0 at the outset anyway. And so if the annual allocation rules change, or if you're coming in as a new sponsor, you may well find you're having to seek through the online system an allocation of certificates in order to go through step 3 of this process. So eligibility, this is the big, politically certainly, element that was discussed at length around the election time, having a points-based system. The points-based system we currently have, which is heading out, is not really points-based in that the minimum point score requirement of 70, they're not tradable. You either satisfy them all or you don't, and you can't actually swap any. So it's no different to having an application form that says, do you satisfy this requirement, and listing those out. Points really were somewhat meaningless in that sense. They're not completely meaningless going forward under this new system, but there's limited relevance. And this slide, which you may well want to take time to look over separately, gives you an indication. 70 points is needed by the applicant to get their work visa under the tier 2, the general work sponsored system, sponsored visa system. You see the first 3 there, they're not tradable, they're mandatory. So if you haven't got the approved sponsor job offer, if it's not at the appropriate skill level, or you can't prove that you speak English to the required level, you're ending up at 50. You won't reach 50 and you can't proceed with the application. You need things in addition to those. So you've got to have all 3 of those. And then you've got to show salary, and you need to gain a certain number of points from this. And this is where the trade-off starts to happen. The standard salary there, minimum, will be 25,600 or above. If you can reach that, your point score exercise stops there. You've reached your 70, you'll see on the right-hand side, a 70, and you've got the minimum points required. If you are just below that, the salaries being offered is 23,040 to 25,559. You get 10 points, which means you've got to find a few more. And then if you look further down, this is where the trading happens. 10 points for that salary, combined with, for example, education in a PhD subject that's relevant to the job, will get you to the 70. So you're trading off the need to have 25,600 above salary for the fact that you've got the middle band of salary combined with the PhD subject relevant to the job. If you're in the lowest of the salary band, so that you see a floor there of 20,480, you've got 0 points for salary, and it is still possible in theory for you to come into the UK. You still need to be paid above that floor there we can see of the 2480. I should stress that. But only if you can trade against 2 of the 3 at the bottom there, the 2 with the green 70s at the side on the left-hand side. The middle one won't get you enough. That's 10 points, gets you 60. If you can show you're in a shortage occupation, which will be designated by the MAC, which is going to be quite important here, I'm sure you're working out and we'll come on to, that gets you to 70. Or if you can show you've got a PhD in a STEM, so a science, technology, engineering, or math subject relevant to the job, both quite narrow requirements, which will not be possible for many people to satisfy. So the overview there, that's a snapshot, but you can see there is a very limited scope for trading points compared to, say, a Canadian or Australian model system, where in fact you may not require sponsorship at all, and in any event you may be genuine, in a more genuine and fundamental way, be able to trade points for things like your age or your level of experience as against other requirements that you don't meet. So just moving forward, lower skilled, there's no current provision short of limited categories like the Youth Mobility Scheme, Tier 5, these are called currently, they're going to carry on. If you are from certain countries and you've come in under a Tier 5 Youth Mobility Scheme visa, well, you can do lower skilled work. Graduate visa to be introduced, which is broadening back out the post-study arrangements for 2 years of working. But otherwise, there is quite openly from the Home Office a statement that we don't have a lower skilled work provision. You might have seen in relation to fruit picking that the government is seeking an army of volunteers to do that this year because of the complete drop-off in numbers of people coming from Europe to do it. We do have agricultural schemes and other schemes outside of these rules which are used for specific sectors, but clearly they're very narrow in scope and won't be relevant or helpful to most watching this webinar, I would imagine. It's a hotly debated issue this week and ongoing. We've got the clap for carers issue set against the fact that the new scheme being proposed actually is set up so that many of those people we would consider key workers in this crisis wouldn't be eligible. You would have seen that on the news. There's a big majority in the Commons, though, for Boris Johnson's government, and perhaps in part for that reason, the reading of the bill introducing this stuff has gone through on its second reading this week. And we still have the issue of pay thresholds, even if there are abilities to say, I can bring this person in at A level, you might still find that the pay thresholds required under this scheme make it not economically viable. So just moving forward. So becoming a sponsor or an approved employer, the government is saying it's recommending applying now. If you are looking at employing people, non-British nationals, people from outside the UK, who are going to start from January onwards. And in fact, the sponsorship process, this new process the government is stating, will be up and running so that you can sponsor EU or EE nationals to begin, do that in the autumn of this year for post, that should be 1st of January 2020. There's a typo there, apologies, around 31st December and 1st of January. So it is possible, the government is saying, or it will be, for you to sponsor EU nationals in the autumn, in the run up to the new system coming into place. I suspect that people watching the webinar will be thinking it would be better if we just get that person to come and live here and start working for us in December rather than January, to avoid all of it. But clearly it's important, if you do have a need to bring people in from outside the UK promptly in the first part of 2021, that's really who this resonates with most, I suspect. You need to apply online. You have to work out your key personnel. Someone who's ultimately responsible for recruitment will be at the top of that list, level 1 users to manage the license. And you need to look at the compliance duties. We regularly do training on this at the outset for people who are becoming sponsors, to HR teams or whoever are in the compliance side of it, to go through what these duties are and how you should try to set up your systems to make your life easier. Cost conundrum, just touching, there's a lot of information on this slide, but I suspect there's going to be a trade-off for many employers between, on the one hand, upskilling your domestic workers or accepting a suboptimal solution on the one hand from the domestic labour market, and the additional cost and time and effort of employing foreign nationals on the other. And in fact, that might be not inconsistent with what the government wants businesses to do when it says we want to wean you off foreign labour. I say that because of the costs predominantly. Becoming a sponsor, if you're charitable or small, is £500 for each 4 years you have your license, or roughly, these are rough numbers, roughly £1,500 if you're medium and non-charitable or above, medium or above and non-charitable. You've then got, this is actually principally and ultimately a cost for the individual applicant, but often it is covered by the employer in relation to recruitment. You've got the immigration health surcharge, £400 a year, looking to go up to over £600 a year per worker and dependent, for a contribution towards their anticipated use of the NHS. So for a single applicant under the current £400 a year rule, that's £1,200 for a 3-year visa. You've got the immigration skills charge then. I touched on it earlier, where the MAC, the Migration Advisory Committee, said we think this is a way to manage the undercutting of the local labour market. It's currently, those two numbers there, £364 a year or £1,000 a year, depending on whether you're small / charitable or medium and above. And so most of the employers we look after or advise are in the £1,000 a year category for this. So that's £3,000 for a single applicant for a 3-year visa in that medium-sized or non-charitable business. It isn't payable for each of their dependents, so the cost doesn't skyrocket in that sense. But it's £1,000 for each year. You've then got a certificate cost when you assign that reference number for them to get their visa. That's just under £200. And they'll have a visa application fee, which you may or may not be contributing to, from around £600, assuming they don't have any premium services. So that then creates this question, for example, of whether you're looking and thinking, well, is an agent's fee and having someone who's maybe perfect through that, or even if they're not, slightly suboptimal, better than, say, £6,500 odd of costs, plus any on costs for for gathering documents, advice. For sponsorship, when you're looking at your first one, of course, some of these costs are first time only, like the sponsor license fee. But you've got thousands in there to consider. Just moving forward. So steps to take now. To the extent you can find the bandwidth, I do quite appreciate that. Obviously, I work in a world looking at this a lot, but there's other things going on for businesses. But if you can, look at the shape of the business and your recruitment plans for the UK. I did mention earlier, I think that's far from easy for most businesses, but if you can, you've got to start to make some assumptions, build some assumptions in around that. Some big changes are coming. Look at your likely hiring patterns specifically on this point in 2021, and particularly the early part. Just look at whether you're going to have a difficulty if in January, someone within the business says, we've got to get this person over from wherever outside the UK and they need to start really quickly. Can you sort that out, please? Well, if we haven't got our license lined up, we might be saying, well, not for at least 20 weeks. No. Is that a problem or not? Can EU applicants' start dates be procured for pre-31st December? Obviously, that makes your life a lot easier on that point about the pinch point there, that you'll be into that brave new world from 11 p.m. on the 31st. And look at the roles you'd want to sponsor as best you can against this new framework. Are you going to find gaps? Are there areas where you'd be inflating pay, having to pay a higher level to get them? Is that right? Or should you relook at the local labour workforce? Does the Tier 5 scheme or graduates, student visas holders offer you a different route? And this is all part of that, essentially that thing of being ready and understanding what the impact of that turning off of the tap of free movement and no longer having the ability to say, oh, we found someone in Paris, French national, perfect for the job, and just saying, oh yeah, come on over, is just not going to be there. Some more, discuss and agree as a business the cost benefit position. Look at that trade-off we just discussed. And also though the competitive advantage or disadvantage of having or not having a license. Does the business feel it puts you on the back foot if you're unable to attract talent from the same broad pool because one of your key competitors has a license and they're getting the talent from outside the UK? Look at your structure and your compliance framework and identify the leanest way to manage compliance. So I should say manage, not manage your compliance duties there. We train on that. As I say, there's a lot of work that you can do to front load the effort, but that will pay forward in the sense of having systems that make reporting easier, monitoring easier, and understanding your duties. Apply for a license if you think you need one, and then in fact you need to be ready for January without any gaps. Perhaps seek support for that in terms of mapping out the process for you, reviewing your application forms, helping you gather the right documents, and seek guidance and training on those duties and compliance duties and record keeping requirements you will have. Becoming a sponsor effectively is like adding another layer of regulation and having an Ofsted inspection waiting around the corner potentially at any time. So you want to make sure you're ready for that possibility that the Home Office case worker might knock on the door and ask to have a look at the files, etc.
Thanks, Adam. That's brilliant. There are a few literally questions coming in the last sort of 7 or 8 minutes. We are now at 11 o'clock, so I think I'm just going to ask you a couple of questions, and I think it's 1 or 2 sentence answers, but I know in the Q&A follow-up you'll give a little bit more detail.
Sure.
So one question is, will the process for renewing your sponsorship license change? Which I think the answer probably is yes, but go on.
The answer is we don't know. But what the government has said is going to be a flexible, and their intimation is it's going to be an easier, more flexible system. So if the EU settlement scheme is anything to go by, that's been online, it's been different government bodies talking to each other, and it's been relatively seamless. So the answer is we don't know, but the hope is that we may move to something that's more akin to that system than the current, to be honest, pretty clunky process that we know online now.
Perfect. Another question. If you are a group of different companies operating under that group banner, does each employing entity need to be a separate sponsor, or can the group apply and recruit for all parts of the business?
Yeah, in most instances, and assuming they don't change this part of the system in a way that they've not yet, because they haven't released all the details, you can choose, it tends to be referred to as branches in the sponsor license application, but you can be a head office, you could be a branch, or you can apply on the basis that it'll be a license covering a number of branches and head office. But that's really within the context of a single employer entity. So in many cases, if you've got different distinct subsidiaries, corporate entities, you may need licenses for more than one.
That's perfect. As I say, I think we're pretty much at time now. So we will do a Q&A follow-up. And just a reminder that the next webinar will be a fortnight today, including changes to the furlough scheme that are due to be announced over the next week or so, and also looking at some of the practical issues of people returning to work, whether physically in the office or just coming off furlough.